Parking lots offer a convenience for people who choose not to walk, bicycle, or use public transportation, and sometimes can be used as a shortcut or a point of access. Yet few New Yorkers give much thought about getting injured in a parking lot when they're simply parking their vehicle or walking through on their way to somewhere else. Unfortunately, just as car accidents can occur in a parking lot, so too can slip and fall mishaps. Parking lot hazards. Parking lots are often exposed to the elements, so there are a number of potentially hazardous conditions that can arise, including potholes, snow and ice buildup, puddles of oil or water, poor lighting, and tripping hazards such as rocks or debris. If you've encountered a parking lot hazard that caused you or a loved one to slip, fall, and get injured, you may be in constant pain, unable to work, and staring down hefty medical bills. You're probably wondering, how will I pay my expenses and get my life back to normal? Options for compensation. You may be entitled to compensation if you've had the misfortune of falling in a parking lot. One way is to file a claim with the negligent party's insurance company. This could be the parking lot owner, a third-party contractor such as a paver, or whoever was responsible to keep the lot safe. Another option to get compensated for your injuries is to file a personal injury lawsuit. The other party can respond to the lawsuit by taking you to court or offering to settle. If you and the other party opt for a settlement, it means that you're agreeing to be paid in exchange for you dropping the legal claim against them. In our experience, settling is a common choice for all parties because it can avoid a long, difficult, and costly trial. Proving negligence after a slip and fall in a parking lot. All of the compensation options, insurance claim, a lawsuit, or a settlement, will require you to demonstrate that the other party was negligent. Negligence essentially means carelessness. Legally speaking, negligence is violating a duty of care. Parents have a duty of care for their children. Drivers have a duty of care to exercise care on the road. And property owners have a duty to ensure that their premises, including parking lots, are safe. In order to prove that a property owner or whoever is responsible for safety of the parking lot was negligent, we will need to establish three things. 1, the existence of that duty. 2, a failure to meet that duty. And 3, that the liable party's negligence caused your injury. At Rosenblum Law, we use things like video footage, photographs, medical reports, incident reports, and eyewitness accounts to help prove our cases. Parking lot slip and fall cases are winnable, but they can be difficult to navigate. Each of the three options to compensation poses unique challenges. Fortunately, the attorneys at Rosenblum Law are versatile, allowing us to skillfully fulfill whatever role your claim may require. If you or a loved one slipped and fell in a New York parking lot and are facing medical bills, missed days at work, and other damages, we'll figure out who's responsible for your injuries, help pursue a claim, and negotiate a fair settlement or take your case to trial so that you can focus on what's really important, getting better and getting your life back on track.